well, we could talk more about the whole questions that you have. Again, I'm also aware of the fact that the questions will be more generic in nature and not specific. And to that extent, I'll try and answer those because these are certain things become very technical. And the intent here is to provide you broad guidelines of what's happening and what's the learning overall in the process. And the learning continues to be large, the learning continues to be very strong, the learning continues to be at a full speed as we speak. And the good news is that a lot of people are paying very good attention to what this succession planning is all about, what is this estate planning all about, and how do you start to think, because these are not easy things to fructify, and especially for the in the culture that we all come with, and especially on the Indian side, we are emotional people. Some of these conversations are uh, not now, but in some places still a taboo, and you don't want to talk about it openly. But I think it's important as the wealth gets created at a frantic pace. How do you actually preserve that? How do you put a structure around it? How do you make sure that these are administratively convenient ways and, more importantly, tax efficient as well? So I'm going to touch on some of those aspects. I have not put in my slides about the family office, but it is turning out to be an important conversation, and time permitting, I will talk about that as well. We are starting to see a fair amount of work happening around family office, and there are various reasons why you would want to create a family office and tie it up with your succession planning and the estate planning, if you will. Uh, Okay, and again, this is a lawyer's disclaimer that don't take this as a it's a general guide, and it's not specific to your situation, because when we are trying to address your situation, it has multiple facets, and that all culminates into a plan that is built customized for you. And these are known situations that all of us have. The idea of putting this was to, this is complex, right? I mean, if it can happen at Tata Group, if it can happen at Infosys, at Raymond's, and it can happen anywhere. And what happens is only the bad things get the press, the good things don't. And you don't want a bad press for sure. And if the good things don't come to the fore, people do understand that it's properly addressed. And we have, very good examples in Pune, like the Bajaj Group, in terms of the way the succession planning happened seamlessly, and with, the event that happened, the unfortunate event that happened earlier this year, did not have any implication, because that was a settled one long time back. And what we have to learn from all of this is that it's a complex exercise. It's not an easy one, and therefore a lot of effort, planning and thinking that needs to go. And it will be, not just days, not just months, but years to invest before a proper plan comes into play. And that does not mean that you don't do, that you just start planning and not doing anything. But there are baby steps that you could do. And my idea is to first provide you with a guideline in terms of, the issues that we see on the ground. And two is, what are the mitigations towards that, and the baby steps that you take to get to the effective succession planning. And there is nothing which is what we call as a perfect succession plan, but there is definitely something what we call as a plan that mitigates most of your objectives, and that meets most of your thought process. And it's a collaborative one. It is, there are disagreements bound to happen with a family that's running a large business and that's managing a decent amount of wealth. So there are bound to be disagreements, and therefore it becomes important to address each of that disagreement and come to a common ground, which effectively mitigates large number of concerns and meets most of your objective. And while you do so, what are the means and tools available is what this whole conversation is all about. And as I said, I'm happy to take questions as we look at. And there are, as I said, ways to make it successful. And even after you do many of these things, there could be situations where it may turn red, and it can happen, right? I mean, it's like competitive exams. You appear for those, the success is not guaranteed. But the fact of the matter is that it's important to start to plan to come to a certain situations. Obviously, you are talking about your ideologies, you're talking about your legacy. You want to secure your assets, you want to put a ring fencing mechanism around your personal assets versus your business assets. You looking at obviously financial stability, uh, not just for you and your family, but also for, and when you are not around, how you would want to look at some of these things. And the other important aspect is a smooth transition, which is very critical, with minimum conflict on business or personal assets. It's a very, very important one. And that's the most difficult part of it. And how do you actually manage that? Look, what we are seeing is there's a host of mergers, acquisitions that are happening. And people, while many a times what we have seen in the past is that someone who's hitting 60, someone who's beyond 65 starts to think about it. And today in the new age business, you are looking at people at 30s and 35s and 40s wanting to exit business, buy business, sell business, and things like that. So life's changing very fast, and therefore how do you effectively manage this smooth transition becomes an important one. This whole thing obviously is to make sure that there is a family bonding that continues and reduces the corner situations, and helps preserves the wealth beyond you, and obviously the business that you have built with such hard work over time. This needs to be efficient. This needs to be unambiguous. Many a times you have seen the disputes arise out of the document, the family constitution that you create, and so on and so forth, is because it's not clearly articulated, and it's done in a hush hush manner, not done with a proper advice. And, or even when that's drafted, even with people like us lawyers, make it so complicated that over a period of 6 months, 12 months, the drafting continues, and people don't know where you started and where you ended, and creates more confusion. So you're looking at many of these things as good tools in your hand to make all of this successful from your perspective. We're talking about various ways, but effectively the estate planning, in whatever shape and form you look at, will culminate into one of these things. And then you can create what you call as a framework, which could be a family office, which could be a LLP, which could be combination of multiple vehicles that could help get to that particular structure. But end of the day, when you talk about your estate planning, when you're talking about your wealth planning and management, you're looking at these three important situations that the law provides you: gift, will, and private trust. You're starting to see a private trust becoming mainstay, with multiple families, with multiple objectives that's being tried. uh, Gift, obviously we all know what is gift, but I'm going to provide you with some of our experience in terms of what actually the gift does and how you could utilize that effectively. And will is an most important thing amongst three. You must create will. There's no other option for each one of you to think that we'll create it later, or whatever, you create whenever, but you must create will. The private trust obviously is voluntary, optional, but as I say, will should become a compulsory wealth management tool as you create one. What's a gift? Gift's nothing else but something that you pass during your existence. When you're living, you give something, that's a gift. And the principle of the gift is that when you give a gift, it has to be accepted by the donee. We call that as a donee, donor, and donee. And then once it's accepted, it can't be revoked. It's a done deal. You don't have a recourse back. And then you're looking at a situation where the gift can be a very effective tool from a tax planning standpoint, from an inheritance standpoint, from a overall saving of stamp duty standpoint, administration standpoint, and so on and so forth. So you're looking at various situations in which the gift can play a vital role. Someone turning 18, someone going to college, a new child born, marriage in the family, and there are various occasions. And in India, we have multiple of those every month that come. And you must use gift as one of the important instruments to distribute your wealth during your lifetime. And the aspect of what you create in will comes into existence after your demise, and even after you have written will, because it's your asset, you could continue to gift as you wish and as you think appropriate. Let me give you an example. When you write a will and say that certain portion of money should go to XYZ, um, at at a following juncture, or you're writing it in a trust saying that if this happens, then you would want something, some of your wealth to move to trust. You could do a similar thing because it's happening during your lifetime. You can gift it and be done and dusted at that point in time. So think about gift as one of the mechanisms that you could utilize while you are alive to distribute to those who you think appropriate. Remember that there's no gift tax at this point in time, uh, but when you gift outside of your family, as is listed under the income tax, then obviously there are challenges in terms of how that gets treated on the tax standpoint. But we are talking about here your family, and therefore I'm not going to travel outside of the family as is defined under the income tax to make it more complex. If it's outside of family, obviously it has to be thought through much differently. But here we are talking about your family, your immediate family, and therefore the gift becomes a extremely viable option. Uh, Let me spend some time on will, because as I mentioned that this to me is one of the most critical instruments in terms of looking at what and how you could plan yourself. And the will can be a very structured one, unstructured one, but should be created is the message. And there are so many anecdotes. I spoke about this last time as well. Is that this lady who's known to everyone? She left her estate to her children and to the former butler, and we know all the story. The point here is that apart from the gossip, the point here is that in will you could do what you want to do, and the person who inherits what you write in the will is effectively getting it from a shield of tax and stuff like that. Obviously it is important that when you write the will, when your immediate family member is not recipient and you're doing it for a purpose, you must make sure you follow the rules of the law just to avoid any kind of later issues and disputes amongst that. What's a will? Very important. Very, very important is that it's a written document and it has to be your last wish, which means that, if you want to change at any point in time, you can change. But then the last will is what counts and not the intermittent wills. And therefore, there's a method in which you must go creating a will. And I'm going to speak about it as we go along. It is, you effectively are able to enjoy your assets during your lifetime, and at after your demise is when the will comes into effect. And therefore whatever you write in the will, suppose you consume it, suppose you gift it, that all is fine, no one stops you. and only the residual assets post all the expenses are settled is something that the beneficiaries would inherit from your will, and that's an important one that you do. And what you write in the will obviously is the manner of distribution of your property as you think, as is your will essentially. And you can obviously use, dispose, gift, or otherwise enjoy the property during your lifetime. There's no bar, there's no hindrance attached to it, there is no ifs and buts about it. It's your property as such. Also important is that the will can be amended on a daily basis, theoretically speaking. And therefore, if and when you think that there is a change in your thought process, change in circumstances, change in major assets, or change in maybe a tax law or any situation, people migrate to other countries, people have different priorities, there's a marriage in the family, and so on and so forth. And then you have a birth of a grandchild and things like that. At all of those times, you could potentially revisit the will. And we do recommend that, the will needs to be revisited at least every 3 years, just to make sure that if you have anything to reflect at that point in time, remember, this is your last wish. So, at every 3-year juncture or 5-year juncture, not more than 5 years for sure, then you're looking at a situation where you would want to make sure that you are looking at creating a properly documented will as such. And one of the important thing is that there's no stamp duty, so which means you are not out of pocket at any point in time. There's no stamp duty when you write a will, and there is nothing which is at least as the current laws suggest on the inherited property tax. There's no inheritance tax as yet, so you are shielded both from a stamp duty as well as an inheritance tax if you're a beneficiary of the will, or when you're doing it, you're doing it with the most in the most efficient manner as the law stands today. What can you do out of the will? And therefore, why is this so important is that you can distribute all kind of properties and assets. There's no restriction. Effectively, whatever is owned by you can be transferred, can be willed, as they call, or can be transferred through will, or can be inherited through will. It could be movable, it could be immovable, it could be tangible. For example, if you have a patent on you, how you deal with that. If you have a trademark, how you deal with that. If you have your email address, how you deal with that. Artwork, jewelry, all of that is clearly something that you could, will and provide clarity in terms of how you would want it distributed. Then you could appoint guardian for your children if they are minor at this point in time, and they need to be looked upon till they become major and are in a position to contract. You could provide with what we call as last rights. What happens to your debts? If there are liabilities, how do you settle them? Any other expense, the executor, if he is to be paid for execution work, there are people who are required to kind of manage the execution of the will as professionals and things like that. All of that can be clearly articulated in your will. You could obviously say that certain sum of money will go to charity. All of that is possible in your will essentially. Now, while we understand the will is important, what you could do, it's also important to look at how do you make sure that the will is valid, and the reason why you need to go and seek professional help. Because, and especially when you're dealing with large assets, why is it important to spend that time with a professional to make sure that you have done what is required as the bare minimum by law? The law gives a lot of flexibility, but law also makes it compulsory from a validity that checks and balances put in the law. And here it goes. One is the fact that the person has to be a major, a minor can't make a will, and he should be of sound mind. It's an important statement. We've seen a lot of Bollywood movies, and there is a particular thinking that comes in our mind, and a perception is built in terms of when the will is written, when it's executed, someone's on dying bed, and all of those. But an important thing is the person has to be of sound mind, and we have had situations where people who are suffering from maybe say depression, or maybe some mental situations, or maybe some disease. How do you deal with those situations become very important to think about. And I'm going to talk about, when I talk about trust, I'll talk something about that as well. The other thing is that will has to be in a written form. You can't record like you record it in on WhatsApp. As yet, that has not been the legal position. The legal position is that it has to be in a written form and must be made during the lifetime by the creator without any influence. So the duress and someone's influencing and things like it has to be his or her free will as such. It has to be signed one clearly, and it has to be attested by two witnesses. Remember, as I said, that the will comes into effect only after the demise of the creator, which means the whole law says that someone has to stand the test if it get questioned in the code of law as to who witnessed the will. And therefore, one of the important ingredient that we all must not forget is that there must be two distinct witnesses. And practical advice is get a witness who is much younger than you, so that the probability of that person outliving you is far more, and you are therefore using known witness, people who are known to you and to the beneficiaries, and also those who are much younger in age as such. You must name executor. That's the recommendation. The law doesn't require it, but then it's an important one. Remember that the beneficiary can be a executor as well. The person who's benefiting can execute as well, but the person who is a beneficiary cannot be a witness. So I can't be the auditor of my own accounts, right? So there's the similar situation, is that a person who is a beneficiary cannot be a witness. However, an executor, someone who's executing, can be a witness. That's what the law says. And as I mentioned to you, that there is no stamp duty payable on the will as such. The effect of a will is that you take away the Hindu or any succession act, which means that if you are Hindu, Muslim, Christian, or Sikh, or Parsi, or whatever, once you create the will, then you're taking away, in most of the cases, you're taking away the personal law situation. Obviously, the Mohammedan laws have a different connotation, but in most of the cases, the effect of the will is that it is your will, and then the law does not come into play. And what is the corollary of it? The corollary is that, if you don't create the will, then the succession law takes over, which means that the property will get distributed in the manner that the law says, except when the other person, so for example, me and my brother are inheriting something, and the parents die intestate, which means without creating a will, then whatever law says that it is to mother and children, then it all goes in that particular proportion, unless the children relinquish their right, or the mother relinquishes the right, or in the permutation or combination. It adds to the complexity, it adds to paperwork, it adds to more time and money being spent, and therefore a will is recommended to be created. I won't go too deep into it. Codicil is nothing else but amendment to the will, which means that you could create a next version of the will. It could be a supplement, or you could write a completely a new will. You could do this every day, but as I said, reflect back on a practical basis every 3 to 5 years, and don't keep it in cupboard without revisiting them. We obviously recommend that the copy of the will should be attached to codicil, so that the document is one. The recommendation is to redo the whole will and not create amendments, because they leave room for interpretation. The idea here is to create something what we call as one document. But if you create an amendment, just one pager or two pager, make sure that you attach the last will that you had created so that the whole paper is at one level. What are we talking about? As best practices, we said that you must name the executor. The question that comes to us more often than not is the registration compulsory? The registration is not compulsory, but we do recommend for various reasons to register the will, especially when you are 60 and above. We do recommend those who are younger, obviously, will have multiple what you call opportunities to amend those wills. Even those people are recommended if the wealth is large to do the registration, but they may not choose to do it for various reasons. Those who are above 60 or 65 must definitely register the will is the recommendation. The second is, on a practical basis, most of the movable properties, if you are able to, and of course immovable property, but more so for movable property, your mutual funds, your PMSs, your broker accounts, your demat accounts, if you have your bank accounts, obviously, if you keep the nomination aligned with what is the beneficiary of your will, then to that extent, when it comes to execution, you're making it simpler for the executor and for the beneficiary to enjoy the fruits of the wealth that you have created and left for the beneficiary as such. We also recommend that the husband and wife should simultaneously create the will and create that separately. Another one is that we do see, this is not here, but we do see a lot of times you have assets in multiple countries. While the law is fine to say that you could create everything under a single will, except in UAE, because those laws are different, we are recommending that create wills of a specific country separately. So for example, if you have assets in US, you have assets in Singapore, keep a Singapore will separate, keep a US will separate, keep a India will separate, simply because the laws that apply to the properties in the US are different than the laws that apply in Singapore or UK or Canada or India. And therefore, to the extent you are able to create these mobility, you are able to create this separation, you will have ease when it comes to execution of your will. And that's true of the trust properties as well, as we talk about it. Doctor's certificate should be attached, and that is an important one to make sure that you are not questioned about the validity, about the soundness of mind and things like that. It takes away and mitigates a lot of legal questions as such. I spoke about the updation, and then obviously I'm repeating this one more time, is that Google can only do so much for you. You don't get the updates as you need and as you think appropriate. Don't go with the dated one. The Google can be used for overall guidance, but can't give you the answers that you're looking at, especially those with large assets as such. I have spoken about it, therefore I'm not going to spend too much of time, but what happens in the absence of will, the law takes over, and that's a complex thing, right? This may lead to fragmentation of property, risk of mismanagement. It takes time to complete the whole process, especially on the immovable properties and so on and so forth. Mutual funds, especially if you don't have nomination, if you don't have a will left, then it's a big challenge in terms of getting it. The mutual fund would rightfully expect you to get a succession certificate, and only then will they provide what is right from a legal standpoint in that way. And there are other instruments as well that get into a lot of issues unless you have created a proper document for succession. Let me see. I have two questions here. What are the advantages of registering the will? So the registration takes there are two advantages of registration. One is that you are taking away all the ifs and buts. The legal requirement there's no compulsory legal requirement to register the will. But when you do register the will, you are effectively taking away all the ifs and buts, whether this is your last will and things like that. So if you create any amendment, you must register the amendment as well. If you're rewriting the will, you must create a registration of that as well. But then the advantage is that you take away the ifs and buts, one, and two, then the probate most of the time may not be required. So if you have properties in, say, Mumbai, Chennai, you need to have probate of the will, which means you need to go to the court and get certification that you are effectively, this is your final will and things like that. All that is taken away at that time. Also, unfortunately, the prevalent practice in India is that many societies or many a place people ask for registered will. It is an unfortunate thing. It's like, people randomly asking you for Aadhaar card, PAN card, and people just don't understand the implication of someone providing the PAN and Aadhaar, but that's randomly asked. And in a similar manner, in a lot of cases, we do encounter a situation where the society has asked for what you call as a probate, or they have called for a registered will and they are not willing to act on unregistered will. Obviously, you can contest that. That's not the correct way of looking at it. But then practically, again, this all gets you in a time situation, money situation. You have to spend extra time and money. To avoid all that, the registration may help you. And as I said, people who are above 60 are recommended for obvious reasons, but there's no legal requirement, but this is a practical way of looking at it. The second question is that if I have first will as registered and the second one is not, which one will be considered valid? The last will is always considered valid, but then you are adding a doubt in the mind of the executor. If someone produces the unregistered will, then from that standpoint, you are looking at a situation where you are, unnecessarily making it difficult administratively for the executor to look at. The other question is that, is it necessary to mention specific investment like the name of scripts, MF details, etc., especially when your investment is dynamic? We do recommend an inventory of all your assets to be properly depicted to the extent you can. Obviously, they are dynamic. Remember what you're trying to do. Again, there are two aspects to it. Is this legally required? The answer is no. Is this practically required? The answer is yes. This is the recommendation, simply because you are providing a complete dump of your inventory of assets, so that at the time when the execution happens, remember that all of this is coming into play when you're not going to be around. No one can speak to you at that time. You cannot help anyone. So your help is the inventory that you can provide to the executor and to the beneficiaries, so that there's no asset that remains in the no man's land. And the fruits of the labor that you have, you have done such a hard work to create the wealth, passes on to the right person as such. The other question is, if the will is registered, is probate still needed to be done for properties in metro cities? At times, yes, but the registered will many a times is accepted as gospel truth, and people may not ask for the probate while you're doing the property transfer. Again, as I mentioned to you, there are practices prevalent which override what is the legal situation, and to avoid what you call legal issues, people go and get the probate done even when the will is registered. Now, the courts have been very clear about it, saying that if your will is registered, probate may not be necessary, because the court is then not actually doing anything. They just need to look at whether there is a certified copy produced before the court of the registered document, and there's nothing else that the court can intervene, and they take registration as the final thing. But many a times, because a probate is what is mandated in metro cities. At that time, people ask for, certain societies would still ask for a probate of the will as such. The other question that comes is, what happens if the beneficiaries are NRI, and how do they get the property or cash? Do they have to pay some taxes? Yes. If the beneficiaries are NRI, the process is the same. The question is, how do they take that money back? So there are two situations. One is of the income tax, and second is FEMA. FEMA allows the non-resident to take $1 million per financial year per person. So, for example, if there's a son and a daughter who's the beneficiary, both of them can take $1 million each in a financial year. The inherited property is not something that you need to pay tax in India on, but so for example, if this money goes to US, in the state in which the person is filing his tax, they need to look at their tax situation in that particular territory, in that particular geography. But the FEMA has a boundary of $1 million, and then depending on whether they intend to utilize the money in India or take back in the country that they're living, they could decide local tax situation as such. There's another question: how can one align MF nomination with will? I think MF normally allows nomination to only one person. In any case, I believe one cannot nominate MFs to all those in the will. That is correct. When you are making a nomination in the mutual fund, you can, again, practically how it's done is $1 million question. But in terms of the legal situation, you could, as you do it with your PPF, you do it with PF, you could say that 50% of the nomination goes to X, 50% goes to Y, which is what your will possibly will say, that you're dividing it equally between the two beneficiaries. And to that extent, you could direct the mutual fund to create nomination in the manner that you want them to, saying that, look, 50% of who I'm nominating is X and 50% is Y. The other question is, will registration where to do? It is with the registrar, the sub-registrar's office. Be rest assured that the registration is foolproof and it's not open for inspection, which means that if I go, I can search for the property records by paying a particular duty, but I will not be in a position to take a search of. It's a confidential document. So the register that is maintained for the will or the private trust is separate than what is maintained for a property document. So you go to the registrar's office and do the registration as such. Is there a time limit between mental fitness certificate from doctor and signing of registration of the will? We do recommend that it has to be of the same date. It can't be dated. The certificate from doctor is not just about the mental fitness, it is about physical fitness as well. And from that standpoint, you're looking at a situation where you would want the certificate and the date of signing of will to be aligned on the same day and not different dates. There's another question, if some beneficiaries are not relatives, any specific caution should be taken? No, I mean, the caution is to follow what you would otherwise follow for your family members and relatives, but just to make sure that a reason being given always helps, so that it is not, no one can then say that the intent was not to give to this one and this was done under duress. So once you write why, say for example, you're giving it to a driver, you're giving it to your maid, you're giving it to a social cause, and if you write a one-line explanation as to why you intend to give it to someone who's not your family, then to that extent it takes away all the intent question at a later point in time, because again, you're not going to be there to explain that. Milind asks, what is a good age to prepare a will? And my answer to that is that, as soon as you get married and you have a responsibility, one must prepare a will. It should not. It should. And again, it is not time bound. It is an event bound thing. Is how we all should actually educate each one of us. So what's the gift to be given during the marriage? The answer from my side is help them prepare a will, or educate them that they need to now get a will as soon as they get married. As such, there's another question: do the witness of the will have to be the same as the registering the will? No. So when you go to the registration, you don't need the witnesses to follow. As such, the witnesses are not required to be present at the time of registration of the will. When you do, the person who is creating the will is the person who needs to be present as such. If I've missed out on any question, do let me know. I'll answer if time permits as such. Private trust is emerging as a gold standard now. It is working out to be an important instrument as the complexity of the family, as the complexity of the business, and the complexity of law all coming together. And this again emerged something where the inheritance tax conversation continues to make noise in the corridors. But aside of that, because the tax is a tax and it's an important element in terms of the planning. But first important thing is to understand as to why do you need to create a private trust, because it's not a easy management and it's not easy to understand. So therefore, it's important that you must make sure that the purpose of the private trust is understood very well, and that you have enough mechanisms to manage that private trust during your lifetime and post your lifetime. Very, very important one, because randomly creating a private trust increases administrative headache, and importantly, that the implementation of it can become complex. And therefore, you're looking at a situation where, while you think about creating a trust, which, as I said, is becoming a gold standard, you would want to question yourself as to what is the objective that you're trying to achieve, and is that objective easy to achieve through something else, or is trust a mechanism to do that? So let me give you an example. When is a trust recommended? So when you have a business and you want that business to continue as a legacy, and you don't want the shares or the interest in the business to be transferred in a manner where it could be detrimental to the other family members, and where multiple family members are actually interested in that particular business, then you are creating a trust. Raymond's, as I showed the picture, is a great example of where it went south in terms of the father and the son, and it's all in public domain in terms of what transpired. And in that way, you are able to control the destiny of your business. You're able to control the shocks that could happen when you transfer something as gift, or you are doing it as a will. What happens is, when the shares are given in the will or through the will, then what I do, if I'm an inherited, if I'm the beneficiary of that will, is entirely up to me. But in the trust, you can define the rules in which the beneficiary can enjoy the fruits of it. And when will trust come to an end? All of those rules of the game: who will be the trustee, who are the beneficiaries, how do you terminate the trustee, how can trustee move out of the trust, all of that, is that an institutional trust or what? All of that can be defined very well in the trust. The second example people create trust is when you're wanting to do charity, and you want to do charity for a long period of time, and there are large number of assets which can be utilized for charity. Or when there is when children are outside of India, and the assets need to continue to be in India for a long period of time and there is an annuity revenue, how do you want to make sure that those that continues unabated? Or if there is any disability of the beneficiary and you want to, and the person is mentally not capable of managing the wealth and the property and he needs support, then you create trust, and you could do for some other esoteric reasons as well. But it's important that you must define what the objective is, test whether it is easier for you to manage the trust, understand that, make the beneficiary understand the rules of the game that you have put in the trust so that there is no misunderstanding. And then, the trustees are able to do what you want the trustees to do as per the trust. The aspect of the private trust is that it's not, again, up for public scrutiny. It is not up for anyone questioning anything, and you're looking at a situation where the private trust can essentially remain completely private. You can register that, you could notarize that. Our recommendation is that when you create a trust, you must register that particular trust, and then you could create something which is so let me give you a structure which is something that we recommend the most, is to say that when you transfer some property to the trust, then the beneficiary is different than the assets in the trust. The trust will have its own PAN, the trust will have its own TAN, and the trust will have its own constitution. At that point in time, the beneficiary cannot do what he otherwise would be able to do during his lifetime. If you are the beneficiary and the assets are owned by you, and when someone else is settling the trust, then you are looking at a situation where you would want to look at whether you want to control those assets during your lifetime and pass them on to the trust after your demise, which means that you could keep utilizing and benefiting from those assets during your lifetime and keep pushing them occasionally, periodically, or through your will, you could push them at, post your demise. Then the assets move to the trust, and then the trust operates that as you have defined during your lifetime. So you create the trust during your lifetime, settle it with some small amount of money, and then pass on through your will most of your assets in that particular trust. And again, that's just as an example, may not be true in all cases. You might want to do most of your assets now rather than later in the trust for some reasons. And again, therefore, I said this presentation is more to make you aware rather than provide a solution which suits your request. And these are some of the terminologies. I'm sure most of you are aware of the settler, the trustees, and the beneficiaries as such, but this is an important element to consider as a private trust as such. Let me take more questions, but again, the idea of the trust in the succession planning is something that I wanted to leave a thought with you that you would want to consider while you're planning. And this is a bigger, deeper topic of conversation to consider in terms of your planning and your succession planning as such, and wealth planning as such. You could have, and the flexibility that the private trust has is immense in terms of appointing the trustees, appointing the beneficiaries, laying down the rules and things like that. You could have what we call as a discretionary trust. You could have a non-discretionary trust like your PMS. Similarly, you can have, and there are implications of creating those, discretionary and non-discretionary trust as such. I'm going to talk very quickly about women and NRI, because we do encounter a lot of situations vis-a-vis women and NRI, and that's something which is, it is most important that women create will more than men because of the peculiar situation that women have under the succession law. Uh, Again, unfortunately, most of the time we do see a male member wanting to create one, but then it is important that, as I mentioned to you, as a good practice, both the husband and wife must simultaneously and separately create the will as such. But you must understand that when a Hindu married woman dies without a will, her class one heirs are husband and children. And in the absence of husband and children, the property goes to husband's heirs, which is, mother-in-law, sister-in-law, brother-in-law, father-in-law, and so on and so forth. And in the absence of husband heirs, it devolves upon woman's mother and father. And there is a lot of complication, not to bore you with that. But therefore, to cut the long story short, it is important to ensure that the woman is actually writing the will as much as the men in the house. And that's something because the laws are complicated when it comes to women, and a woman who is widowed and the woman who is, and so we can talk about multiple permutation and combination vis-a-vis a woman. Non-resident Indian and estate planning. Again, I'm talking about from the creator's perspective, but also from the beneficiary's perspective. There was a question and I answered that question. But if you are a non-resident Indian and you are creating a will, or maybe your relatives are passed this on, that you must make separate country-specific will. You are allowed to make a will in India to cover your assets in India, and that can have a multiple implications to you of making or not making the will, and prepare a separate will if you have a immovable property and movable property. If it's a movable property, then it's that much easier. But if you have an immovable property, then it is imperative that the will gets created with a specific mention of those immovable properties in the document to avoid any kind of what I call as further complications when it comes to that. Someone asked this particular question on probate, and as I said, the law doesn't require once the will is registered, probate is not essential. But at times, practically, we have seen it otherwise. Probate is nothing but a certified copy by the competent court to say that this is the final will, and there's a process that they follow. There's another concept of what we call as a succession certificate. Succession certificate is something that the legal heirs need to produce to claim the assets, and that's done through the court process when a person dies without leaving a will as such. This is what I wanted to talk about overall in terms of my presentation. I'll just go through some more questions that have come. Aishwarya, if I've missed out on any question, do bring that to my attention.
Sure.
So there's a question from Nitin Deshpande asking, in case of jointly owned property between husband and wife, does the will only apply to one partner's share in his or her will? Yes, depending on who dies first, the will apply in relation to the assets of that particular person. And depending on how the will is written, you then have succession or inheritance noted in that particular manner. So for example, if the husband dies before the wife, how husband's share in the property is to be distributed will need to be understood from the way the will has been written. I don't know if I answered this particular question, but then a joint will can be done first. Second, if husband dies in my example, then and whatever is husband's share in the movable and immovable property, it will devolve on the beneficiary in the manner that has been stated in the will. Uh, the law is very clear in that you can only will what is your property and not your wife's or your children's property, right? So effectively the will can only transfer what is owned by you, what share is owned by you in that particular property, and nothing more than that. Can you guide on the beneficiary of the will, a son uh, who is NRI and in US? What are the complexity? No, there is no complexity as such. The son who is a non-resident Indian can be the beneficiary one, and he can take the money, $1 million in a financial year under FEMA, and he has to only comply with the local tax laws. He will not have to pay taxes in India as such. Uh, there's another question. If you do not have close family member who can be entrusted with your funds to be used for looking after you when you are old, and is the trust a good way of managing that situation? Yes, exactly. The trust is a great way of doing it. When you create, when the settler creates the trust and you are the beneficiary of that particular trust, you can have a professional trustee or someone who you trust to be a trustee can take care of that. And there are professional trusteeship companies who help make that work essentially. The other question is, if beneficiaries of will or executor is not aware of my will, which is registered, unregistered, as you say, registered office will not. Yeah, I mean, that's a great question, actually. So the idea, and I should have put that in my slide, is to say that, you must give one copy to the executor. So say, for example, if I'm executor and I have no idea that I'm executor of the will, there's no way I will even know about it. So the idea is that, say, for example, if I'm one of the executor and there's in my absence another executor, you would want to ensure that you would want to give a copy of the will to the executor. Usually copy of the will is not given to the beneficiary for the obvious reasons, but a copy of the will should be given to an executor so that he's aware, one, what is where is that particular will, is that last will, and also, if he has any question about the assets and if he has any clarification to seek, then it becomes important. I'll give an example. Jewelry, usually, people say that create a 50-50, or if there are three beneficiaries, four beneficiaries, do a equal distribution. Or someone will say that give this necklace to my daughter-in-law and my daughter or whatever. Now, how do you identify, who will identify your jewelry becomes a $1 million question. Unless the will is properly done, you've kept a photo or you kept a video, or you tagged it in a proper manner. And therefore, it is important that you explain the will to the executor. The executor knows your assets. He has a general idea of what is there, so that there's no situation that you are then dealing with it. There's another question, whether a private trust is required to be registered and required stamp duty. No, there's no stamp duty. You do it on a 500 rupees stamp paper as such. And we do recommend that the private trust be registered, though it is not compulsory again. But given that it's a trust, many a times you need to give a copy of that trust to a lot of places, and there the registration always helps. There's another question: is it a good practice to give copy of registered will to the beneficiaries? No, I'm particularly against this aspect of giving a copy to the beneficiary. You must give a copy to the executor, because, and if the executor is the beneficiary, so be it, then that's fine. But he's getting it as an executor and not as a beneficiary as such, but not to the beneficiary. Can you elaborate the concept of living will? Yes, the living will is a possibility today. The jurisprudence is evolving as we speak and will continue to evolve as we have more living will cases. Living will essentially means what you want to do when you are in a dying situation. How do you want to create your own will at that point in time when you are living, but at a stage where a decision making is not possible for you to do. For example, someone with Parkinson's disease, or someone with something which is essentially uh, someone who's with some other uh, disease situation and is not even able to sign, not able to create a power of attorney, not able to provide anything which is bank requires it, etc. At that time, this living will all comes into great effect as such. But the law is evolving. The law will fructify over a period of time. Once we have more of these cases, but we are recommending, think through that while you're writing your will. What do you want to do in certain situations if you would want to cover those in your will as such. Another question is registration of trust settling movable property stamp duty. Yes, that's a question, and it's a gray area in terms of while you settle the immovable property, how do you deal with the stamp duty, and how do you actually do the registration part of it? Because remember that the name changes, though. Remember that the trust name cannot be on the immovable property because it's not a it's not a separate legal person like a partnership firm, but the trustee's name appear, and if the trustee's name is the same as your the property in which the beneficiary's name, then that's a gray area, and the law again is evolving as such. I do not know what is oral trust, honestly, so I'll find out and maybe answer it separately. But I don't. I have never seen an oral trust that's got created. How one can distribute assets owned in HUF and partly individual through the will. Again, HUF is a concept which where you are looking at a karta, and you can define in HUF what is the succession in that HUF. So it is not through the will, but it is through the HUF document itself. You could decide as to how you would want to reconstitute beyond you what happens of that HUF as such. Another question for properties in Pune: what is the procedure to transfer the property to beneficiary, especially in case where society is still not formed? Need to look at it on a case specific basis as to why is the situation, and if is that something which the builder needs to do, or what needs to happen. But you should put that as a clear indication in your will in terms of what is the situation currently while you're writing the will. And if the society gets created at a later point in time, so be it. If the society is not created, still through the will, you will get replaced by the beneficiary. The society formation is a mere formality. Your asset is your asset. What you want to do through your will is to transfer the interest in that asset to your beneficiary, and to that extent, you will be all right creating that as such. Will in contemplation of death, I don't know actually what the question is as such, so I'll skip that right now. A will which is not registered, will it be binding on bank MF? Yes, as per law, it should be. But practically, as I mentioned to you, at some places we have seen unnecessary questioning, and therefore the suggestion to register the will to avoid. If you have done the will, that's the 90% of the job done. The 90% of the effort is to create the will. Take that 10% extra effort to register the will, especially if you are 60 plus, and especially if you are 65 plus. We are 10 minutes over the time. Thank you for your patient hearing. Any other questions? My email, or on my slide I have this email. Just drop in an email and we'll be most happy to answer the questions.
Yes, thank you so much, Vivek. Sir, that was a very insightful session. And it's pretty evident from the kind of interaction we have received from our clients that it's proved to be immensely helpful. We would definitely need to have a follow-up session in view of all the questions that we have been getting. But for anyone who would like to reach out to Mr. Sadhale, we will share his coordinates definitely, and you can reach out to him for any questions one-on-one, or any personal guidance or advice as required. We have also recorded the session, so we would be sharing a copy of the recording with each and every one of you. So yes, I'm just handing over the stage to Praveen sir. Yeah, thank you.
Hi Vivek. I think it was. I think thanks for taking so many questions. I think I never expected. We thought we'll complete this session in one go, but appears we should have made some couple of days to address this issue. And of course, this topic is so vast. I'm pretty sure you may take a complete session for our clients separately, maybe on one of the offsites or one of the client events, something of that sort I'm contemplating. Just a couple of things. There are some two technical questions which I had observed. Like in case of this nomination in terms of mutual funds, so question, like you can do multiple nominations, like you can keep your 3 kids with different sharings and all that. That is possible, that you can do directly. And I think there is one more query was there regarding this taking money outside of India by the beneficiaries of the will. So I believe that if it is inherited property, will get eventually sold due to the demise of the person who is doing will, and beneficiaries in turn inherit some property and money. RBI allows that relaxation in that 1 million type of a limit. That's my understanding. We still have to go and check. But in a case of inherited property sale and proceeds coming to the beneficiary, there could be some relaxation from RBI. I think we have gone and done in a couple of cases, more than $1 million.
That's correct.
Just thought of,
no, that is absolutely right. The default is $1 million, and you could reach out to RBI. And,
you are on a mute, Vivek. Okay. Yeah. Sorry.
So no, you are absolutely right. The default is $1 million, and with an RBI permission, you can actually go and seek exemption and seek to remit more than $1 million.
Yeah. Okay. Great. I think thank you so much. It was really helpful. We'll try and work out one more session because I'm pretty sure there are many questions people are to. Either they can come to you straight away. I'll share your number and email address whenever they want to. And looking forward to have one more session from you in due course. Thank you so much for spending time, and thanks everyone for joining.
Thank you so much, sir. Thanks for hosting this. This is an important topic, and any questions are most welcome. Happy to answer.